नमस्ते, एपीएन और इंडिया लीगल में आपका स्वागत है। 171 ऐतिहासिक फैसले, 307 बेंचों में प्रतिनिधित्व, सिक्किम हाई कोर्ट के चीफ जस्टिस से सुप्रीम कोर्ट के जज बनने वाले पहले जज, एक ऐसे जज जिनकी संवैधानिक हकों और सामाजिक न्याय के प्रति समर्पण और प्रतिबद्धता हमेशा अटूट रही है। जी हाँ, हम बात कर रहे हैं जस्टिस माहेश्वरी की। हाल ही में जस्टिस माहेश्वरी ने सुप्रीम कोर्ट के जजशिप से रिटायर किया है। आज हमारे शो में वे मौजूद हैं। वेलकम टू द शो सर।
Thank you. Let's talk about your initial days. You came up from somewhere in Madhya Pradesh, Jorena district. You come up to this heights. What does it make you feel?
Certainly, I came from a very village background. This was a place where in 1972 dacoit surrender was there. And I have seen sitting Jayaprakash Narayan, essence of Barao at my home. So I was inspired that the legal process, if it is not duly adopted, what may be a consequence of it? So this creates an impact. Then I started. I worked initially guided by my brother, who was an advocate. Then later I joined, after doing my law profession, law degree, I joined Justice R.C. Lauti. I worked with him. I earned the principles on which he has worked in Gwalior. Really, then realized this thing, that it is a noble profession and how we have to work in that. And slowly, by my hard work, understanding the basic principle of nobility, I started functioning in Gwalior. Within some time, I became a leading advocate and then add-on to the bench. So this was my journey in short.
अक्टूबर 2019 में आप आंध्र प्रदेश के पहले मुख्य न्यायाधीश बने। पूरा जुडिशियल सेटअप आपने वहां तैयार किया और खास तौर पर जो केस लोड है उसको बहुत अच्छी तरीके से हैंडल किया। लगभग 4500 केसेस को आपने रिजॉल्व किया। अब ये एक बहुत बड़ी चुनौती थी एक नया सेटअप में, जुडिशियल सेटअप में करने। तो उस चुनौती के बारे में हमें बताएं, कुछ एनेक्डोट्स हैं तो हमें बताएं जो कि चैलेंजिंग रही, और मोस्ट इम्पॉर्टेंटली जो पेंडेंसी को हैंडल करने का एक्सपीरियंस था इन कंटेक्स्ट ऑफ टुडे, जब वेरी हाई पेंडेंसी जुडिशरी में है और कई तरह के इनिशिएटिव्स लिए जा रहे हैं। आपका क्या उसमें सॉल्यूशंस हैं, व्यू पॉइंट है, कैसे प्रोसीड करें? तो बेसिकली ओवरऑल आप पिक्चर दें।
जब मैं चीफ जस्टिस ऑफ आंध्र प्रदेश ज्वाइन किया, आई फाउंड आफ्टर टेकिंग ओथ एंड रिज्यूमिंग ऑफिस that out of 13, in 11 districts there was a strike. When I asked my brother and sister judges what is the reason of the strike, they communicated me that the strike is because now new regime of the government has offered 3 capitals. 6 districts opposed to it, 4 districts for to it, and 1 district is neutral. So I asked, what is the concern of this with the functioning of the court? They said, sir, here the peoples are divided, so we can't help. I persuaded my brother and sister judges. In every high court, every district is being dealt with by one judge. Sometimes we say administrative judge, sometimes we say portfolio judge of that district. I requested them, please discuss with the members of the bar. This issue is completely different and alien to our judicial process. So we should not go on it. And if you feel that's still issue, I am ready to have a talk with everyone. After 3-4 days, all judges came and they said, sir, they are not agreeable of it. I got prepared a note, what rights they can have, how we can go in this issue, because until all district courts is starting functioning, it is mounting of the again cases. So then I said, please convey them, all district presidents, secretaries and their executive may sit along with the district judge and senior most ADJ with chief judicial magistrate. I will hear all 13 districts and let them answer to me. I taken an unprecedented move. You are asking of the anecdotes. I am telling you, this was an unprecedented move from a chief justice. I asked with everyone, yes, what are your problems, which is essentially to be resolved by the High Court in dispensation of the justice, or what is the reason why we are on strike and how far we can go ahead now in future. After detailed discussion, it's a marathon meeting of more than 2 hours, and after that meeting, 7 districts immediately withdrawn the strike. I told them, under the provisions of the Reorganization Act, notification ought to be issued for the state. If something would be done, recourse is permissible under the law. If some otherwise is there, court would look into. But can it be an issue on the hem of the persons who is having a trust and confidence coming to the court that they must have a decision in the court? They have a belief on our system. This will not carry on. Then 7 started. 4 districts sought time. I granted time. 1, Visakhapatnam, not agreed. They demanded that let there should be a bench here of the High Court. And no, this is another issue. And later when they came, I get it resolved, this first issue. So this is a first way to resolve this issue and to carry on the work. The intention was everybody should have a work culture, and that work culture must come not only from the Chief Justice, it is a concise effort of all judges. That is why I could do. All judges were sitting with me while I hold this meeting. So then they agreed for. As such, we started functioning. When we found that in the High Court, the cases which came about 9-10 months back, they're lying on the floor. I visited to the entire premises. I found that how it can be arranged first in the Almiras and then thereafter. I saw the sanction strength was more than 1100 staff. Out of them, we have only 300. How the functioning of the court can be carried on? Then in that situation, some staff was on deputation. So I get arranged it. This is prior to COVID. Because I joined in the October 19. So COVID came in March 20.
This is Hyderabad.
This is Vijayawada. So COVID start हुआ, उससे पहले मैंने ये चालू कर दिया. तो I could well arrange the files. Now I could ask how you can go for the bunching of the files, subject matters. So I got some judges. Please find out subject matters. Can we bunch of it? Stale matters. Can we do it? And we did this work. In this work, my all brother and sister judges cooperated me a lot. Members of the bar cooperated. and all our staff, they worked day and night. Because I used to sit in the office by 9:30 or 9:45 and leaving 7:30. So they were aware the Chief Justice will come and he will work. So they all worked with us. So it's a concerted effort of everyone. I cannot claim myself that I did this. It is in fact a concerted effort of everyone. Then slowly, we have come to the COVID. When COVID came, I received so many complaints on email on the Chief Justice's portal. I found these are very serious, that is relatable to the medical issues of the general public. So at that time, I treated some of the complaint as a petition. And first on 25th of March, on Zoom platform, I started this hearing by this virtual courts.
तो ये पहली बार आपका ये
First, this was my first. Then first issue arises.
इससे पहले देश में कहीं
No,
नहीं,
no,
तो
it
वो
was
इनिशिएटिव आपका सबसे पहला है,
This
ऐतिहासिक।
was mine. So then we started 25th of March. Then the issue came before in my mind. Then if we will not prepare a rule and a valid way of drafting and filing of the cases, how we can take up those cases? So I requested some brother judges. I requested 3 judges to prepare this platform, this filing module, and 2 judges were assigned to have this preparation of the SOP. Not, we can't prepare the rules like that. Suppose High Court can prepare, but it should go to the state government and approval must be there. So I said SOP may be prepared. So as such, we prepared SOP. And with the help of my brother and sister judges, within 3-4 days, we could have done it. Then we have taken a step that call virtually all members of the bar, and we should have explained them how you have to file the case, e-filing. So we explained, SOP notified, and members of the bar cooperated because they were feeling that how the cases should be filed, urgent cases should be filed. So we did it. And accordingly, we started functioning. Then some stale matters. Then the basic problem was that I was having 300 staff. As per the guideline, only 30%, 50% can come, 30%. So how, if 100 comes, then how the High Court can run? Then I requested some of my staff who were on deputation, they want to go back. I requested them, please don't go. I will send you back prior to leaving of this place, but please work for the institution. They worked. Then we get engaged some contractual staff on the requested to the government. Initially, the government was reluctant, but finally they have understand. So they granted me contractual. So we get. Then I said on deputation persons, okay, please give them training, how they have to work in a court. Then they started functioning. Assigned one judge. You please look after this. And as such, we cope up the work. And by God's grace, as per the E-committee report, we were having 18 judges at that time out of the strength of 37, but we could heard 94,000 cases during that period.
ये तो ऐतिहासिक था। आज के परिप्रेक्ष्य में अगर हम देखें जिस तरीके से पेंडेंसी बढ़ रही है, इनिशिएटिव तो सुप्रीम कोर्ट की तरफ से आ ही रही, आपका इसमें क्या नजरिया है, क्या कुछ और किया जा सकता है? लोअर कोर्ट्स में, डिस्ट्रिक्ट कोर्ट्स में जो जिस तरीके से केस अब फाइल कर रही है, चलिए सुप्रीम कोर्ट में तो बेंचेस वगैरह बन गई हैं नई पुराने केसेस के लिए, मगर जो लोअर कोर्ट्स में जो बैकलॉग जैम्स हो उसके लिए क्या किया जा सकता है?
We have to say that it should be divided in 2 parts. One is arrears and one is pendency. If we overall purview it, as per the Law Commission report, the prescribed strength required as per 10 lakh is 50. But Indian judiciary is working with 20. My intention is not to point out against any institution or any system. So certainly there is a dearth. So this is not only judges, then again infrastructure, again assisting staff. So all this is there. So this is one part, how we can cope up, and the executive as well as the judiciary should jointly work on this. This is one part. Second part, cases which are pending in the court. If you see those pendency in the court, sometimes as per my experience, either side asks for time, we can check those adjournment to some extent, but not for reasonable causes, because otherwise it would be denial of the justice. So this is another. Third, we should have regulate our listing. Listing pattern must be as much as cases a judge can hear, should not be more than that. Otherwise, if suppose being a judge, I can hear 40 cases, but it is listed 60, 70, it will be bound to be adjourned on that day. So it must be a listing, and the cases, if it is listed, an attempt must be made by everyone how we can go and dispose of the cases. Our all judges are, I can tell you, working more than as much as their own strength. They are compromising their personal life always. They are working with high standards. Then after hearing, and you have to write the judgments when you can. When you can, you must have a time of it. Every day as a judge of the Supreme Court, I required 4 to 5 hours to read the file of the next day.
4 to 5 hours.
4 to 5 hours, file of the next day. And after, if I have heard that case, I have Saturday, Sunday. Saturday, Sunday, I have one Judicial Academy, I have to go National Judicial Academy, I have to go for some lecture. Then you have to work for it. Then sometime when these partial working days comes, then we work on it. At least 50% of the partial working days goes with every judge to deliver their pending judgments. So this is a way. If you ask me a way how it can be reduced, pendency. For the old pendency, strength must be increased, infrastructure must be increased, and the assisting staff must be provided. For new cases, we have to go for the alternative method, and the mindset must be created to the litigant, like mediation, arbitration, and conciliation. And that mindset of the litigant must is required. If the mindset of the litigant is not there, they would not go and decide that by way of mediation. So हमको बहुत जरूरी है, जब तक mediation mindset नहीं होगा, जब तक आदमी mediation में नहीं जाएगा. Sometimes what happens, we have experienced here in Supreme Court while working or as a High Court judge, people fed up. And at that stage, when the case is coming for, why this is a family matter, why you are fighting? This is a commercial matter, why you are fighting? Go and sit and decide it. Then people goes. And the result in those cases, 10%. It is of my experience, in my working, in my bench. I can say of this much, that comes with resolution. So the resolution is always better. So we have to go on this method. We have to increase the mediation mindset. We have to increase those commercial litigations differently. And the mediators must be proficient in a subject. Thereby, they know this may be a reality and this may be a right answer of this. And as such, if a litigant who is coming with a trust and confidence in a judicial system, that we will go there and we will ask justice, then when dispensing, even by way of mediation, but this would be a justice delivery, access to justice to them, real. So that must be done, and we should not shy away of it. We should have go on this.
There is talk of a proposed law in Bengal which would allow the detention
of a suspect for a year without legal representation. Critics say there are enough laws already. Why are our laws getting draconian?
Your question may be relevant. And such question, bringing of the law, is a domain of the parliament and the legislature. If the law enacted, and that is for suspects, all right, then in that situation, if you see the provision of the Constitution, Constitution also provide for preventive detention. So preventive detention is also a law for suspect. But there are certain exceptions prescribed, how in what manner such law must be. And therefore, if you see Article 21 of the Constitution, it says no person shall be, because such law gives a detention and affecting personal liberty. So Article 21 says no person shall be deprived by his personal liberty except according to procedure established by law. The due process has been converted to procedure established by 42nd. So now this is there. So once, if came, either this law came for challenge, then it may be looked into in the anvil of Article 21, whether how far it affects or not affects. Article 22, preventive detention, prescribed therein. Second, law made, and in individual case, they prescribed a procedure, 15 days, then thereafter something, then that may be done by them. So if it may be looked into by a board, though without representation, that may be a affecting issue, then all this can be assailed in the individual case. And fact to fact cases, court usually decide, and Article 21 matters, I'm telling you, court takes up at the earliest. This is the endeavor of altogether all the courts. Otherwise, if some request is being made, this is a matter of the detention, court takes it. Those matters, even in a priority has been given in a Supreme Court matters, because it being taken at part to habeas corpus or otherwise. So that can be looked into, but in general, we can't say this may be going to be draconian or otherwise. Because we see in every state, there is a provision like this. So NSA, there is a provision. Constitution, there is a provision. State-wise, some Bootleggers Act and some state acts are there. So this act, if any came, at present we can't say draconian until it is being examined by the court of law when it is assailed. Where is this challenge?
जी, आर्टिफिशियल इंटेलिजेंस के बारे में अगर बात करते हैं तो इसमें अच्छे पहलू भी हैं। कोर्ट की प्रोसीजर्स काफ़ी तेज़ी से हो रही हैं, लॉयर्स उसको इस्तेमाल कर रहे हैं, मगर इसका एक डाउन साइड भी है। गलत केस कोर्ट किए जा रहे हैं और भी कई तरह की चीज़ें जिसका सुप्रीम कोर्ट ने संज्ञान लिया था और कुछ गार्ड रेल्स भी बनाए थे, है ना। लॉन्ग टर्म में और शॉर्ट टर्म में इसका जो गैर जिम्मेदाराना इस्तेमाल हो रहा है, उसको आप कैसे देखते हैं? किस तरीके से इसको और कर्व किया जाए, कैसे रेगुलेट किया जा सकता है?
संजय, पहले तो मैं एक बात बताना चाहूंगा, it's a artificial intelligence. So word used is artificial. Who is intelligent? Human being is human brain is intelligent. So it is used as a artificial intelligence. Now everything starts from this word. If you see, and its utilization for collection of data, collection of facts, it can be utilized with caution, because the artificial intelligence is a mechanical, it's a tool prepared by a human brain, and that tool doesn't know anything. It knows as artificial, it is trained brain. Number types of cases are there. As much as you will feed, whatever you will feed, you will get an answer of it. Because in an artificial, this is not a brain understanding what we are talking about. तो ये आर्टिफिशियल जब है तो इंपॉर्टेंट पार्ट ये है। दूसरा अगर अपन देखें तो डाटा प्राइवेसी। तीसरी चीज अगर अपन देखें, इसके आगे चलते हैं, तो आर्टिफिशियल इंटेलिजेंस में दो चीजें, हेलुसिनेशन एंड एल्गोरिथम। ठीक, दोनों की बात करते हैं अपन। ठीक, यदि हम देखें कि भाई ये क्या हुआ, क्या रखा, जो फीड किया उसका आंसर दे दिया, जो फीड ही नहीं हुआ आंसर ही नहीं हुआ। ठीक, क्या उसको मालूम है इस केस के फैक्ट्स क्या थे, विटनेसेस ने क्या कहा, उनका बिहेवियर कोर्ट में कैसा था, वो कुछ नहीं कर सकते, बता नहीं सकता। उनने तो 2+2 4 होते हैं बता दिया, फाइन। लेकिन एंटायर प्रोसीजर, सो व्हाट आई सजेस्ट इज, it's intelligent but artificial, and human brain is intelligent, so this cannot replace the mind of a judge and behavior all which is coming. You know, in courts what happened, witnesses come, they are tutored witnesses, witnesses come, they are telling lie, they are supporting somebody, and what has to be done by a system, two things use, access to justice when entering and dispensation of justice when coming out. So by way of artificial intelligence, how far dispensation of justice, looking every endeavor of witnesses, every endeavor of the persons appearing in that situation can be availed, I have a little doubt on it, and this cannot replace the mind of a judge. This can assist, I can say, in compilation of the facts and tools.
गलत इस्तेमाल करने वालों पर लगाम लगी। जो
It must be. It must be. The reason are two. Peoples do have a trust and confidence on our system. हमारे सामने आप गलत फैक्ट्स पे केस बना के पेश करोगे और फिर हमसे चाहोगे कि आप इसको रिलाई करके ऑर्डर कर दीजिए, क्या ये संभव है? संभव नहीं है। जब ये संभव नहीं है और ये गलत तथ्य, पहली बात तो गलत तथ्य कोर्ट में आना ही नहीं चाहिए। आपने जजमेंट ही नहीं है ऑन रिकॉर्ड, आपने जजमेंट बना दिया, पेश कर दिया आपने फेवर का, दिस कैन बी डन बाय एवरीवन, सो देयर मस्ट बी चेक ऑन एवरीथिंग, एंड रिसेंटली चीफ जस्टिस ऑफ इंडिया हैज embarked upon, and that is rightly, I can say so, it must be.
This is related to the first question. Now, over this bail of Sharjeel Imam and Umar Khalid, there has been a difference of opinion among judges. You know, most for people, the Supreme Court is seen as this one huge monolith. So, doesn't it send conflicting signals to people? Just a question.
I will answer this. I know the bail is the rule and jail is the law. Suppose that is there, but when a case comes to the individual judge and they look into whether the bail can be granted or not, so many factors is required to be considered by a judge. Here sometime it happens that the judges looking to the facts may of the view such type of offense I feel it heinous, but the other judge may not feel it, and the bail is a discretion. So at that time, in exercise of the discretion, there may be some discrepancies, maybe, because many minds, many finds, we can do this. But consistency must be maintained. Though in bail cases, it is not always that the precedent should be followed. It should be looked into. And if some observations and some directions has come and some difference of opinion has come, it will go in a 3-judges bench. Then that may be resolved, that what may be the guiding principle for grant of the bail. I am using the word guiding principle for grant of the bail. And here you can understand facts of the case, discretion of a judge. So they can give a guiding factor if some difference of opinion is there. So that should not be looked into in a way that there is a difference much more and divergent opinions.
कोर्टरूम में इनडिसिप्लिन काफी देखा जा रहा है पिछले कई महीनों से। अगर हम देखें तो कई इंस्टेंसेस आए हैं लॉयर्स इनडिसिप्लिनरी तरीके से बिहेव कर रहे हैं। आप 2002 में ग्वालियर बेंच में अनुशासन समिति के अध्यक्ष भी रहे, इस तरह की चीजों का आपने सामना भी किया है। तो और अभी सुप्रीम कोर्ट ने तो डिसिप्लिनरी एक्शन पर बीसीआई के कार्रवाई की, ऑडिट की भी उन्होंने परमिशन दी है। तो क्यों ऐसा हो रहा है? क्या बार अपने काम से पूरी तरह से जिम्मेदाराना तरीके से उसको अंजाम नहीं दे रहा है? कहीं सॉफ्टनेस है? क्यों इस तरीके से बिहेवियर कोर्ट रूम में आ रहे हैं और जजेस को किस तरीके से इसको हैंडल करने में परेशानी?
On the disciplinary cases, certainly I was the chairman of the disciplinary committee when I was the member of the bar council in Madhya Pradesh of the Gwalior bench. The lawyers as well must be looked into when you are seeing the case of a disciplinary committee in the context of that litigants, because by their act, it's an act of misconduct by an advocate. Alright, so by his act, what is going to be affected? It's a trust and confidence is going to be eroded in the manner by using some otherwise practices. So this is the basic part for disciplinary cases of the advocates. The another part is कोर्ट में इस तरह की घटनाएं बढ़ती जा रही हैं। ठीक है, हम देखें पहले वाले पार्ट में अनुशासनात्मक समिति वाला, एडवोकेट्स के लिए एक कोड ऑफ कंडक्ट है। क्यों बनाया गया? क्योंकि इसको नोवेल प्रोफेशन माना गया and every advocate must have a code of conduct, ethics. So if they don't follow, they deal with the cases. Then it comes to the Samiti, and when we decide those cases, it may be looked into whether his act is amounting to misconduct or not. So that may be looked into. But if you go in the present judgment, Justice Narasimha and Justice Alok Radhe probably, this is a delivered judgment formulated one committee. The Bar Council itself welcomed that judgment, certain directions, and they said it is a welcoming step. The intention was the functioning of our institution. I am not taking as only advocate or as a judge. Our institution reputation should not be eroded either by an act of the advocates or by any behavior or giving a latitude to those advocates and some sympathy, not required sympathy. That should not be go on. So in that context, BCI accepted it. They have to do the audit and something as per the directions. The behavior of the advocates in the court is concerned. Certainly some incidents has been reported. In that, two things we have to mark. If they are arguing on the facts of the case and law, persuasively, forcefully, even a loud voice, it should not be feel offending. But if indecent behavior which is not expected, it is required to be dealt with and nip at the bud. This is my opinion. Otherwise, somewhere it will create issues in future and it will affect our institution and reputation of institution.
एक सवाल इससे जुड़ा हुआ है सर। बार को कई बार देखा गया है कि वो गलत चीजों को सपोर्ट करता है। जैसे अभी जो अयोध्या चंदा मामले में लॉयर्स ने बोला कि हम केस नहीं लड़ेंगे, अयोध्या बार ने उसको सपोर्ट किया। उसी तरीके से पिछले कई रेप केसेस, दिल्ली रेप केसेस वगैरह में भी केस नहीं लड़ने की बात थी, सपोर्ट किया गया। तो बार को तो एथिकली एक्सेस टू जस्टिस को सपोर्ट करना चाहिए, मगर अगर इस तरीके के लॉर्ड्स के बिहेवियर को, उनको रिप्रेजेंट नहीं करने की बात को वो लोग सपोर्ट कर रहे हैं, तो दैट्स अगेंस्ट। तो मेरा कहना है, मेरा सवाल ये है सर कि बार क्या कहीं नर्म, कहीं अपनी जिम्मेदारियों से हट रहा है चीजों में, बार एसोसिएशंस?
Certainly, your question is very much relevant. Our basic principle of dispensation of justice is no one should be condemned unheard. And if in an adversarial litigation process, if the person is not being represented, meaning thereby somewhere he is lacking in legal assistance in the court of law. So, if general this decision is being taken, in my personal opinion, this bar should introspect how far such decisions ought to be taken. Or suppose anybody comes and represent that person, and where some indecent act comes reported, that must be introspected by the members of the bar. I should not comment on it, but principally, if you ask me, such decisions should not be taken in general. Everybody should be given an opportunity of hearing. Court will decide what is right, what is wrong. On moral principles, if we say so, not going the process of law, meaning thereby we are punishing a person merely on moral principles. That should not be done. Otherwise, it will affect our institution and it will erode the trust and confidence.
You've been part of the Collegium. How does it accommodate differences of opinion among the judges?
I can tell you one thing. So far as Collegium and difference of opinion is concerned, that is bound to be. But the decision is collective.
Okay.
Always. And when decision is collective, this difference of opinion is not bad.
Yeah.
Differences of opinion is good for discussion.
Yeah.
When after discussion, we find, can know what we, suppose I am in any difference of opinion with other judges, I will put what is the reason of my difference of opinion. If I put, it may be accepted, may not be accepted. But the decision is collective and final. Hardly if it is not, even I am not agreeing, I may not agree, then the decision would be taken on the basis of the majority. And it will go to the government finally. So the government may look into and find out the truth and can recommend and can accept, not accept.
इसी से जुड़ा एक सवाल है सर, ट्रांसफर्स पर काफी सवाल उठे हैं कि जजेस पे जो ट्रांसफर्स होते हैं उसमें पॉलिटिकल प्रेशर पड़ता है, और ऐसे कुछ इंस्टेंसेस भी हैं, किसी का देर रात ट्रांसफर हो जाता है, किसी का कुछ छोटे हाई कोर्ट में ट्रांसफर हो जाता है, जो सुप्रीम कोर्ट की हो जा रहा था उसकी हो जाती है। तो कॉलेजियम कई सारे इस तरीके के, किस तरीके का प्रेशर्स बियर करते हैं कॉलेजियम में, कितना दबाव पड़ता है, कैसे हैंडल किया जाता है सब चीजें?
Again, we do not, if any information is being given by any source, we do not treat as a pressure. Information has come, that this issue has cropped up, this is a situation, please deal with this. In a matter of transfer, usually we look into whether it may going to be affected to our institution or not. And if that we found somewhere it is going to be affected and that person may be displaced from that particular place to some other place, so then issue can be resolved during that period. And then thereafter we also consider for repatriation to them also. So we do not feel that we are transferring under a pressure or some otherwise things, because we have to ultimately look into कि if ये सिचुएशन कंटिन्यू रही तो इंस्टीट्यूशन पर इसका इफेक्ट एडवर्स आएगा या पॉजिटिव आएगा, तो हमको ये बात कंसीडर करना पड़ती है कई बार। और Transfer is not a punishment.
कभी कभी यूज किया गया है, इंस्टेंसेस हैं सर.
देखिए, इंस्टेंसेस का जहां तक मैं समझता हूँ, कई बार ये भी परिस्थितियां होती हैं कि हम जिस तरह से उसको इंस्टेंस को कंसीडर कर रहे हैं और जो ऑन रिकॉर्ड है वो सामने नहीं आ पाती बात. ये भी होता है और कुछ सामने आ जाती है, ठीक है ना. तो यूजुअली हम लोग इस तरह से नहीं सोचते. हम सोचते हैं कि सपोज इट इज सम इंटेग्रिटी इश्यूज, इन सम करेक्टर इश्यूज, और सम वहां पर नहीं हुआ तो it would be unrest among the people and it is affecting the institution. Then we thought let it be, because हर चीज को सप्रेस नहीं किया जा सकता, हर चीज को डिटरेंट वे में डील नहीं किया जा सकता. तो फिर उसका तरीका सिंपलिसिटी ये है कि भाई हम उनको we switch them and by that time the person gets a lesson and then we consider for. So sometime it happens, but we usually, I can only say normally we don't go on any of the pressure. We consider what is the material and then only we do. I was a part of it, I know.
Yes, sir. Of course. Okay, related to this, social media. How sensitive should judges be to social media criticism? Anybody can say anything, right?
To my mind, social media criticism, we have to see any of
Are you on social media? Do you have Instagram?
सर सिटिंग जजेस सोशल मीडिया में एक्टिव रहते हैं क्या, या
नहीं.
देखते हैं क्या?
very less.
हाउ डू दे गेट द फीडबैक?
And then we get the feedback. We have our research system. They come forward with us. कि sir, this is going on. This you gave this judgment. Then on this judgment, this is a criticism. This is an article written. This is that. So they come with that. We look into what should be the parameter. I'm on the parameters affecting the judges, and otherwise the judges should not affect by this social media. Let them do what a person want to do. Social media, it's a person who want to put some post can put a post. We have no problem in that. Social media posts, we have to be influenced by that. Suppose any issue raised, and if you examine it's introspecting that, suppose it is on a judgment, any issue has come, fair criticism is permissible of a judgment, but if social media says no, not a criticism on a judgment or a law, but they go on a personal level, they go on an institutional level, this is wrong. So the judges must look into, introspect. If something wrong, see, judges are also human beings. They can, sometime it have a mistake also. We can correct it. If they are right, you should not react. See, correct yourself in your judgments if you can, and go ahead. Nothing. So we should not much influence. And otherwise, every day we see in social media this murder, every day TV, this is trial. All media trials are there. If we start influencing with that, you can understand. Though it should be stopped. Should not be there. There must be a limit of everything. But because it influences the mind of a common man. Everybody may not be a so confident, the strong-headed man like me. I will not understand. I will understand law is this. I will go by this and finish. Namaste.
एक सवाल है फ्रीडम ऑफ एक्सप्रेशन वर्सेस सेल्फ रेगुलेशन. काफी कई जजमेंट्स आई थी, सटायरिस्ट, कॉमेडियंस वगैरह कोर्ट में आए. कभी उनको फटकार लगी, कभी पुलिस को फटकार लगी. इन द सेंस दैट कभी लॉ का गलत इस्तेमाल किया गया, कभी जो सटायरिस्ट थे वो लाइन क्रॉस कर गए. अब ये बड़ा ही क्रिटिकल चीज है, क्योंकि लॉज कुछ ऐसे बने हुए हैं जिससे अगर कोई किसी चीफ मिनिस्टर या किसी को कार्टून बना दिया या कुछ बोल दिया तो वो उसको कैन बी बुक्ड. तो क्या इसका बेजा इस्तेमाल हो रहा है, इस तरीके के लेजिस्लेशंस का बेजा इस्तेमाल हो रहा है? और जब कोर्ट के सामने मामला आता है तो किस तरीके से कोर्ट इन सब चीजों को देखती है? पिछले दिन तो काफी कुछ हुआ कॉमेडियन.
देखिए, मैं किसी कोर्ट में पर्टिकुलर केस की कोई कमेंट नहीं करूंगा. हाउ एज ए जज I had perceived and what is my thinking part on such post or otherwise.
Only that, sir.
my thinking part is freedom of speech and expression is under part 3 of the Constitution with exceptions. Certain law has been made taking note of those exceptions. Alright, recent BNS and BNSS, some provisions have been introduced. Prima facie, when a case comes to a court, the court must look into with a conception whether it is with an intent of freedom of speech and expression, giving a valid point with bona fides, or this is with malafide or with intent of mens rea. So this must be a thin line to look into, and such cases must be decided. We should not have curtailed this abruptly, absolutely, otherwise Article 19 would be affected. But at the same time, some unscrupulous persons who are doing this intentionally only to defame or otherwise to do something that should not be left. So my perception is like this, and it is based on individual case and the let it be decided case to case basis.
Sir, like doctors, judges are looked upon as divinities by people of India. And in between, you have these. How does it weigh on you? How does it weigh on you?
What is particular question you want to ask me?
The question I'm asking you is, like, people imagine judges are infallible, right? And how does it weigh on you as a person dispensing justice?
I will answer in very simple way of this. Who are being made judge? People, citizen.
Yeah.
And if you see old days, if you see new days, what was the standard of the morals and what was the standard of morals now? Decline. If some issue comes like this, so we have to perceive in this perspective. The judges, whenever they have taken the oath, you see what is the wordings used in the oath. In the name of God, और संविधान की शपथ लेते हैं कि हम जो कुछ भी करेंगे वो विधि के अनुरूप और ये करेंगे अपनी एबिलिटी के अनुसार. तो जब हम ये शपथ लेते हैं तो हमको उस शपथ का ध्यान रखना चाहिए और हमको ये देखना चाहिए कि हम कोई भी एक्ट ऐसा ना करें जिससे कम से कम पब्लिक कॉन्फिडेंस एरोड हो रहा है. जजेस आर ह्यूमन बीइंग, ऑलराइट, दे हैव टू गो, उनको जाना चाहिए, लेकिन व्हाइल वर्किंग इन ए कोर्ट दे मस्ट हैव अंडरस्टैंड दे है लाइन, व्हाट इज द लाइन. और यदि किसी जज को लाइन समझ में आ गई कि जब मैं घर आ गया और घर में फैमिली, मेरे दोस्त यार, मैं मिल सकता हूं, बट मैं कोर्ट में जाता हूं, तो कोर्ट में फिर उसको समझ रहना चाहिए कि केस है तो मैं वैसे ही डिसाइड करूंगा. ये मॉरल डिक्लिनेशन की वजह से मैं आपको क्यों मैंने ये एग्जांपल दिया, मैंने अपनी आइज से एक हाई कोर्ट में पिताजी जज हैं, लड़का वकील है, दोनों एक गाड़ी में आ रहे हैं, केस लग रहा है उसका उसी जज के यहाँ, पिताजी के यहाँ केस लगा है, ठीक है, और वो जब उसका केस सुनते हैं तो कहते हैं नो मिस्टर यू हैव नो केस. ठीक, ये डेक्लिनेशन की वजह से कहां तक पहुंचे हम, होगा ही नहीं, उसके यहाँ जाएंगे ही नहीं, उनका रिश्तेदार नहीं होगा. अब तो जज बनाते हैं हाई कोर्ट में तो कहते हैं 2 साल तक वो प्रैक्टिस नहीं कर सकते आपके किट हैंड के, ये इसीलिए हुआ ना. तो हमको जब हम ओथ लेते हैं तो हमको ये समझ लेना चाहिए कि हमको किन पैरामीटर्स पे वर्क करना है. और यदि कोई भी व्यक्ति है जो जज इन पैरामीटर्स पे वर्क करता है तो मुझे नहीं लगता कहीं प्रॉब्लम होती है. आई डिड माई सोशल वर्क टू मच, मैंने किया है, एंड आई डिड इट फॉर द बेनिफिट ऑफ द डाउन टू एंड पुअर. आई हैव ए मेडिकल कैंप इन द नेम ऑफ माई मदर एट माई बर्थ प्लेस. हाँ, मैं करता हूँ और 2 दिन जाके काम करता हूँ, खुद काम करता हूँ खड़े होके वहां. इसमें क्या गलत बात है? आई एम डूइंग फॉर द पब्लिक. सो वी डू this like this. So we should know this our
Parameters.
parameters. लाइन क्रॉस नहीं करने का.
मेरा लास्ट सवाल आपसे सर ये रहेगा कि जुडिशियल ओवररीच के मामले में न्यायपालिका पर काफी उंगलियां उठती रही. 142 के इसमें कंप्लीट जस्टिस के हिसाब से भी काफी केसेस किए रहते हैं. तो इसके दो पहलू रहते हैं. एक तो इसकी कंप्लीट जस्टिस दी जाती है, कभी कभी एग्जीक्यूटिव के पाले के फील्ड में भी जाके कुछ चीजें सही करने की कोशिश की जाती रही है. तो ये जो ओवरऑल जुडिशियल ओवररीच का जो मामला है उसको कैसे देखते हैं? क्या रियली लक्ष्मण रेखा पार कर रही है? क्योंकि गवर्नमेंट की तरफ से हमेशा आता है कि जुडिशरी लक्ष्मण रेखा पार कर दी जाती है कभी कभी. तो कैसे देखते हैं?
आई वुड नॉट कमेंट ऑन एनीथिंग. गवर्नमेंट इस तरह से कहती है या नहीं कहती है. मैं आपको एक एग्जांपल देता हूँ. विशाखा केस कब डिसाइड हुआ और कितने दिन बाद लॉ आया? पॉश कितने दिन बाद आया? पॉश एक्ट 13 साल बाद, जजमेंट के बाद. अगर आर्टिकल 142 का हमने इस्तेमाल नहीं किया होता, ठीक है, क्या होता? ठीक. जब भी हम कोई केस डिसाइड करते हैं, आपने देखा होगा फॉर डूइंग कंप्लीट जस्टिस वी आर डूइंग दिस थिंग. ठीक है. अब केस के फैक्ट्स किसके सामने है? कोर्ट के सामने. नॉट विथ एवरीबडी. फाइन. जब कोर्ट के सामने फैक्ट है तो क्या होगा? वी हैव टू ऑप्शंस. We are judges. Either can pass orders or judgments. Being a common citizen, would you not think this must be nearer to truth and the dispensation of the justice must be there? And at that time, what comes in the mind of a judge for dispensation of the justice? And if it feels, yes, this would be a real justice, can be done. I can put an example. Recently, one matter came before me, in which POXO Act was attacked. Both were in, one is 16, 17 years girl, boy was of 23, 24 years. They fall in love alone. FIR registered, she gave a statement against, and thereafter conviction. Fine. Came before us. In the meantime, I was not in the bench. It was with a different bench. Different bench passed an order. She said, no, I want to go with him in a court. And when her statement was recorded, it was not that much clear. So when this matter came before me, then I said, her statement may be recorded again. And in that statement has come, my marriage was done. And thereafter, my marriage broken down because of this incident. Then third statement came in which she said कि no, मेरी शादी अब इससे हो गई है. ठीक. अब वो कहती है कि मुझे इसके साथ रहना है. मेरा प्रश्न है आपसे, इन परिस्थितियों में अब हमारे पास स्टेटमेंट रिकॉर्ड में आ गया, दोनों तीनों स्टेटमेंट आ गए, और उस समय मैंने 10 लाख रुपए सिक्योरिटी उसके कंपनसेशन के हिसाब से दिला दिए, और आज वो रहना चाहती है, उसके साथ शादी कर लिया दोबारा से, तो अब क्या करना चाहिए? कंप्लीट जस्टिस करना चाहिए या नहीं करना चाहिए? We did it. So we exercised 142 and did it. Otherwise क्या होगा? This man will go for 10 years inside, 20 years inside. This will be socially discarded रहेगी. She will go with some other person, and you see what would be a social impact of it. We have to look into these aspects. जहां कंसेंसस आ गया, सब कुछ आ गया, हमारे सामने आ गया, स्टेटमेंट हमने रिकॉर्ड करा लिया, हमारे सामने आके लड़की बोलती है, क्या करें? उसको कहें जाने दो, you should go with a draconian law. Can't go. So these are certain examples we can put in.
There is talk that this POXO adolescent love should be exempted from POXO purview. Talk is also there.
I would not say for all causes it should be,
Yeah.
but what I want to convey is our at school level, at least there must be a primary teaching. This must be, POXO is stringent law.
Yeah.
और आप भी जानते हैं, मैं भी जानता हूँ, 50% केसेस में ये सब विद कंसेंसस होता है, बट दैट कंसेंट बिकॉज ऑफ द माइनर इट कैन नॉट बी, एडल्सेंट इज देयर,
Yeah.
कैन नॉट बी ट्रीटेड एज ए कंसेंट, एंड सब्सिक्वेंटली सोशल इम्पैक्ट होता है, फैमिली प्रेशर्स होते हैं, ये हो जाता है, सो एक लाइफ रुइंड हो रही है। तो उन बच्चों को मुझे लगता है, तो मेरा थॉट प्रोसेस है कि बच्चों को इस तरह का एक प्राइमरी
Yeah.
टीचिंग
Education.
एट 8th to 12th लेवल, बिकॉज ये एज उसी पीरियड की है,
Yeah.
उस पीरियड में कहीं ना कहीं एक इस तरह का लेक्चर मंथ में जरूर होना चाहिए, जिसलिए उनको लॉ के बारे में बताएं और भाई आप लोग बी केयरफुल ऑफ दिस। आई थिंक दैट मे बी ए राइट अप्रोच फॉर
Yeah.
आवर डेवलपमेंट ऑफ सोसाइटी। आई विल टॉक इन नॉट जनरल ऑफ सोसाइटी, नॉट ऑफ इंडिविजुअल अगेंस्ट एनीवन।
तो ये थे जस्टिस माहेश्वरी, जिन्होंने बहुत ही बेबाकी के साथ न्यायपालिका से जुड़े तमाम सीधे सवालों का बहुत खुल के जवाब दिया। APN और इंडिया लीगल में आने के लिए आपका स्वागत है सर।